Alex here with part 78 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We're about to go into my ex's response to my petition for writ of mandamus. So at this point, I have filed the petition with the Supreme Court of Nevada. The government has responded, and now we're waiting on my ex to respond. I will have the opportunity to reply to both the government's response and my ex's response, but that's going to come up later in my docket series. The only thing I can think about right now is that I distinctly remember thinking that my ex's attorney's answer to my petition was better than the government's. I thought that the government response was a lot weaker than my ex's attorney's response, but I haven't looked at this ahead of time, so I might change my mind. When we go through this document, I'll try and remember that I want to do a comparison again, and towards the end of the document, I will mention if I stand by what I thought. I don't know how many years ago, 9 years ago now, 2012, 8 years ago, or if I change my mind and I think that maybe they're the same or maybe the government's answer is better. All of that being said, there isn't really much else we could cover in this video, so we should go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's response to my petition for writ of mandamus. First thing I noticed is the upper left-hand corner should have the attorney information. It's a little odd that it's not there, but for whatever reason, she didn't put it in. First paragraph is the standard introductory paragraph. My ex is appearing through and by her attorney, Kathrine Berning, and she is answering my petition for writ of mandamus. Statement of the case, it looks to be that I'm looking to learn the confidential or the actual address of my ex, specifically because that's where my son lives. My ex was supplied a confidential address in 2009, and her receiving this confidential address occurred pursuant to the law. Claiming the right to know where my son resides, I am seeking disclosure of her confidential address. For the most part, that's accurate. Issues. I am presenting a sole issue before the court, whether the law authorizes the government to issue a fictitious address based on the mere existence of a TPO, or whether the government has to consider the substance of the TPO prior to issuing the fictitious address. And it says here that my ex concurs with the state of Nevada that there must be a mandatory duty for the secretary to disclose. What is she talking about? There must be a mandatory duty for the secretary to disclose her address. I guess they're saying that the secretary has to be ordered to turn over the address, which is true. It's just a little bit hard to understand there. Statement of the facts. Petitioner and my ex cohabited with our child. Relationship ended in 2008. There were 2 calls to the police, and then they reference both exhibits 1 and 2. Next, we have an assertion that I instituted child custody proceedings in District 2, Washoe County. And then they follow up with the fact that my ex sought a TPO against me in a separate case, also Washoe County, and that she was granted the TPO. We already know all this. At the hearing, she related that she'd been pushed down stairs. This is stuff that, if the court had made findings, this might have actually worked. But the court didn't make findings, and that kind of scares me because it makes me think, wow, this case could have hinged on what, in my opinion, is a domestic master who was incompetent in her position. But and if anyone's going to feel like that's a cheap shot at the domestic master, when I went through the My Docket series very early on, you can see the actual hearing for yourself. I believe it's part 8 of the My Docket series. And the thing that I had a problem with is the domestic master didn't base her findings on the evidence. And in fact, it was very contradictory, both the evidence that my ex submitted and the statements that she made. She also made an admission in court that none of these things ever occurred. So why is she citing this here? She said that she was... So this is even worse because my ex's attorney is indicating that these things occurred, and then she's leaving out the fact that later on, during that same hearing, my ex withdrew those statements. So it's first you have deceptions by the ex, and then you have deceptions by the attorney. Anyway, the thing that bothered me about the domestic master is she said she based her findings on the fact that my ex sounded very believable. She didn't base that on any of the actual events, any of the contradictory actions that she took, etc., etc. And I talk about one of the problems with making a decision if you're a judge based on how believable somebody sounds. And the reason is that sometimes people, especially those with mental health issues, actually believe what they're saying is true even though it's not. So it's a better gauge to actually look at the evidence that's been submitted and the statements that are being made to see if there are contradictions in those statements or in the evidence. Because if you just go by, oh, well, that person sounded believable, what about the people who aren't telling the truth, but they believe their own lies? What about the people who have mental health issues that don't really understand that reality objectively is not the same as reality subjectively? In other words, their perception of what's going on isn't what's actually going on. And that's, I think, what's been going on in this entire case is mental health issues. But anyway, to think that she could have just made findings like that and I'd be stuck is pretty scary. Luckily, she didn't do that. And luckily, my ex ended up admitting to none of these things having occurred within that hearing. If anyone, again, wants to see the hearing for themselves, just go to part 8 of the My Docket series and you'll get to take a look at it from beginning to end. Next statement is child custody order was entered. Secretary of State's answer to the petition. Exhibit 4 is the actual copy of the order. We share joint legal and joint physical custody. Next statement is that at a review hearing in the case, my ex's attorney told the court that I take a firearm with me to meetings. Why is this relevant too? Ms. Farrar told the court that besides showing up at exchanges, I have made comments. None of these things are true. But it doesn't matter because the court hasn't made findings. So these things can't be used against me. These are things that came up later that the court disregarded. The court inquired as to why provocative things would be done at exchanges. Okay, so I get what she's doing. The lawyer is using the argument of since I'm not a good person, therefore I should lose this case. But none of this is relevant to any of the Supreme Court doesn't talk about this at all. You guys are going to find all this stuff that she's saying, this incendiary stuff. The Supreme Court just ignores it. None of this is relevant to whether or not a confidential address should issue. They've just decided to make me look like a crazy person, and they're hoping that if I look like a crazy person, the Supreme Court will rule in their favor. They'll just ignore all of the statutes, they'll just ignore the Constitution, and Alex shouldn't be exercising his Second Amendment rights, or he's doing things that are upsetting to everybody involved. Okay, moving on to the next paragraph. I am stating in the hearing that in my experience... Oh, she sticks to this. I can see why at the time I would have said that my ex's attorney made the better arguments. She really drills this home. So again, everyone that's watching this and the way she beats this into the ground, you'll be surprised at the fact that in the publication this isn't mentioned at all. Next assertion is that she applied for a confidential address by the Secretary of State. And by the way, she applied for this address prior to any of these things occurring. It might have been in between the two hearings, but I don't think it was. I think it was before both hearings. In any event, it doesn't matter because it's not relevant either. Even I'm getting sucked into these arguments. So let's see. She's applying for the confidential address by the Secretary of State, and then the next assertion is that I filed a petition for judicial review in the lower court, which I did. The next assertion here is that I filed a notice of appeal. The appeal was denied on the basis that there was no jurisdiction, since the Secretary's decision was not reviewable as a contested case. That's correct. Next assertion is that the Supreme Court, that I appealed that decision and that the Supreme Court affirmed. And then the next assertion is that I filed this writ petition. So that's pretty much consistent with what the Secretary stated. Next, we have the summary of the argument. The law provides that a writ of mandamus shall issue to compel the performance of an act. Same exact thing that the government said. They're saying that the Secretary of State has no duty to disclose the address, especially when the program was established for use by people in her situation. Argument. My ex has reviewed and joins Secretary of State's argument set forth in the Secretary of State's answer, and my ex would point out the following. So I'm assuming she's going to point out a few additional things. The TPO that my ex was granted has served as an adequate basis for receiving... Okay, of course, consistent with the law. The temporary protection order provided the specific evidence showing that the child Okay, so now they're trying to conflate the two statutes, which isn't true. So they're trying to say that subsection 4 of 462 satisfies subsection 2A of 462, which isn't true, and the Supreme Court rejects this argument. Next is that, or it might actually, and the Supreme Court just strikes it down as not consistent with the Constitution. One of the two things occurs. We'll take a closer look when we get to the opinion. Next, we have in the fight against DV, the legislature established a confidential address program as an important tool against fighting against it. My ex applied for the TPO because she'd been etc., etc. And the reason I'm not mentioning this too much is because it's going to yellow flag my video, which I don't want to happen. I want to make sure I keep this video green. And if anyone's wondering why, yellow flag videos are not released to as many people as green flag videos. Green flag videos, YouTube distributes much more widely than yellow flag, which is a controversial video. And I'm trying to avoid mentioning certain things because I'm trying to avoid the video being yellow flagged. But you can read it for yourself in the text, so you'll know what I'm talking about. And as you can see, I'm using abbreviations for DV, for example. With her approval for a fictitious address, the location of the home was safe from intrusion, but she had to endure threats. After the TPO was dissolved, I wasted no time in obtaining firearms. So then this would be consistent with the fact that she had already used this prior to any of that stuff even having occurred anyway. So she's using so-called evidence after the fact to try to support something that she had done prior, which is it's a common thing that attorneys do. Oftentimes, they'll ask for something that they don't have the proof for, and then they'll hope that sometime in the future from that date, that you'll do something that they can then use as proof to say, hey, look, since he's doing all these other things after our request, that means he was probably doing all those other things prior to our request as well. And this is one of the reasons why I talk about the importance of understanding optics in child custody cases. It doesn't matter if you're doing something that's legal. If it looks bad, it's going to be used against you. So yes, of course, in hindsight, I would take all those actions back because it would make my case more of a slam dunk. But luckily, I ended up winning the case anyway, so it didn't actually affect me. Next is, as cited by the secretary, my ex's proof of a TPO is the highest level of proof required. What? That's incredibly weak, though. So they're saying that the use of a TPO is the highest level of proof required in any states with the fictitious address program. And my argument is that that's terribly weak because you can get a TPO without showing proof of DV having occurred. As I've talked about in numerous videos in the My Docket series, you can get a TPO just by claiming the possibility of DV may be occurring in the future. You don't need to actually show that you've been a victim to get a TPO. You just need to show that you might become a victim. And so this is definitely a very terrible standard across all 50 states if that's indeed true, that's the highest level. Next we have, the judge, after hearing evidence, verified a real, yeah, right. That's why she ordered it for 3 months. So they're trying to say that the domestic master found a real threat and determined that my ex should be protected. But if this is true, the domestic master would have extended it for a year, not just for 3 months. So number one, the domestic master would have made findings consistent with all these crazy things that my ex's attorney is arguing. And then number two, the domestic master would have extended it for a year because she would have thought that was a real threat. She wouldn't say, oh my goodness, you're in danger. This is the worst thing I've ever seen. This is a very real threat. We're just going to protect you for 3 months only. You're going to be fine for the other 9 months after that. That makes no sense at all. For the court to allow a party to circumvent the protection by requiring the release of the address works as an injustice to my ex. The Supreme Court disagrees with this because of the Constitution. If we didn't have the Constitution, she probably would have won this case. Most likely she would have won this case. Let's see. As is evident from the minutes of the hearings, the parties have had no trouble in communicating. It's also plain that I have not been denied access. This isn't true at all. There was extensive lengths that my ex took to deny access, but it's also a distraction because none of this is relevant. So they're trying to say that since I have enough communication with my ex anyway, that it's okay that some of my rights are being violated. It's the same thing that the government said. The government is basically saying, hey, since he still has contact with his son, it's okay that he doesn't know where he lives. All these other things that he's getting are just good enough. Next, we have the language in the law, which is clear and must be given effect. When a statute's language is clear and ambiguous, so this is a rule of statutory construction. This is a great thing for my ex's attorney to bring up. If you want to learn more about statutory construction, watch my video on the topic because I have a video dedicated just to this one thing. And yes, the plain language rule in cases like this is actually really powerful. If the Constitution was not applicable to this case, most likely, I'm like 99% sure, the plain language rule would apply. The statute 217.462 would be held to control, and that would be the end of the case. Next, we have the assertion that I have no right to know my son's address while in my ex's custody. I have a right as a joint legal and joint physical custodian to share in decision-making process, but no right to the address. So again, I bet it seems to me like my ex's attorney has basically jumped off the same bridge that the government's attorney has. She's going to take the position that parents don't have a right to know where their child resides. But this isn't as bold as the statement that the government stated, because in a way she might insinuate here that this is because of the circumstances of the case. No, she's totally bought into the government's argument. If you just take a look at the last sentence here. So she's saying that she concurs with the position of the government, which is that I do not have a legally recognized interest in knowing my son's resident. So it gives me pause to read something like that. Because this is a statement that isn't just applying to my case. What these attorneys are saying is that no parent anywhere in the country has a right to know where their child resides when in their ex's custody. That's what they're saying. And that's a really scary thing. I mean, because to me, it doesn't even come close to true. To me, it's like way out in the boonies. This is an argument that's so far off the reservation that I can't even believe they're both taking the position. But they are. And then we go into the conclusion. And we have that my ex has obtained a TPO. She has obtained a fictitious address for the same purpose. She submits that she was properly approved for the fictitious address and that I have no right to know the location of my son. Dang. I did not remember them taking this position. Wow. All right, onward. We have the affirmation pursuant to the law, and this is indicative that they have reviewed the document and they submitted it to the Supreme Court, having reviewed and made sure that there are no social security numbers in the document. Certificate of service by mail, indicating that the response to the petition was mailed to my address. Index of exhibits. Did she attach them to this? So they're not supposed to do this. They're supposed to include this as an appendix. And they're not doing that. They're just attaching exhibits to the back. So it's like nobody really knows how to do this writ petition. Everybody's just kind of guessing, including me. But you'd think that these attorneys would know how to file an appellate brief properly. What they were supposed to do is file a separate document called the appendix. And in the appendix, there's going to be an index of exhibits. And inside of the index itself, you're going to see what happens is after the index, you're going to see all of the exhibits, but they're not going to be separated by exhibit sheets. They're just going to be bait stamped. And then there's going to be a table of contents in the index that contains the pages that you can go to find each specific paper. So neither myself, the government, nor my ex's attorney have filed any of these documents correctly. We're all just kind of putting them together sloppily. Okay, Exhibit 1, which is the minutes, which I've already gone over. And in fact, I'm going to just take a quick look at Exhibit 2. More minutes. So these minutes are basic. Why are they even using these? You're not allowed to do that. Okay. There's another video, and I think I talk about it in the video proposed orders. You can't use minutes. And the reason the Supreme Court says so is because the minutes aren't actually a reflection of the court's order. The minutes themselves mean nothing because the final written order is what actually controls in any of these cases. And in fact, they've stated, I think the case is Rust v. something. The Supreme Court of Nevada has stated that you can't, that oral pronouncement from the bench, including minutes, are ineffective for any purpose. So this attorney is using these two pieces of paper that they can't be considered. The Supreme Court of Nevada is going to ignore them. And over again, the Supreme Court tells attorneys they can't consider these. So, by the way, I think it makes a lot of sense because minutes aren't even prepared by the judge anyway. Minutes are prepared by a clerk, somebody who sits next to the judge. They just type them up. So what the Supreme Court wants is a final written order that's signed by the judge, or you can use transcripts, but you can't use minutes. So this is a very rookie mistake for the attorney to make. Maybe she's just never done any appellate work before, so she doesn't know. Okay, next document. Verification by my ex. Okay, so this is a mistake too. So the verification was supposed to be included in the answer to the petition. But what happened was she probably forgot to do this, and somebody told her she needed to file it. Most likely the Supreme Court called her up and said, hey, you forgot your verification. Or it's possible that the government's lawyer called her up and told her the same thing. The verification is the piece of paper where the person who's involved in the suit, in this case it's my ex, it's where they swear under penalty of perjury that all of the facts alleged in the particular pleading are true. And so without a verification, the thing that you're filing is inconsistent with the court rules. It's in violation of the rule, and that's because it's full of all of these assertions or allegations, but nobody's swearing any of it's true under oath, so that's a problem. So anyway, what she did was just prepare it as a separate filing, and then she just filed it separately, which you can do. And then we got the affirmation again. And then another certificate of service by mail indicating that this specific verification was both mailed to the government's attorney and to me. Here we have the certificate of service by fax and U.S. mail. And apparently sent a true and correct copy. Oh, so I see. She forgot. Okay, so she's fixing a bunch of her mistakes. So this previous filing was because she forgot the verification. And this certificate of service here was because she forgot to file a certificate of service proving that she mailed this to the government's lawyer. If you look at the original certificate of service in the actual answer that she filed, it only indicates that she served the document to me. So she had to file this separately because she forgot to include the government in that certificate. So both of these papers, these last two papers, is just them clearing up things that they forgot to do. And now we have an order from the Supreme Court. And the Supreme Court of Nevada is ordering the clerk of the Supreme Court to file my reply to the respondent's answer and notice regarding real party and interest preferred mailing address provisionally received by this court. And my answer to the writ petition. Why did they withhold this? Weird. So for some reason, the clerk of the court withheld my filings, my replies to both of the previous answers that we went over in the series. And the Supreme Court of Nevada is basically telling him, why'd you guys do that? You need to file those. So the documents that were provisionally received and not filed by the clerk of the Supreme Court are now going to be filed by order of Justice Hardesty. Going into the aftermath, I did not file any of these documents, so I incurred $0 in costs. The government didn't file any of these documents either, so the government would have incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The government would have reviewed these filings, but I don't imagine that they would care a whole lot because it's not like they have to take any action afterwards. They're pretty much done. They're pretty much just waiting for a ruling. So I imagine that all the government would have really bothered to do is upload these files to their system, and that's it. And maybe update some details as to when, I don't know, they need to check and see if there's been a decision yet, something like that. So I'm going to go ahead and put all 4 of these filings, well, I don't know. Yeah, I don't think they would really care too much to review even my ex's attorney's filing. There's just the fact of the matter is there's no more work for the government to do. So I'm going to go ahead and put it at 15 minutes for all 4 of those filings, which is going to come to $62.50 in attorney fees for the government. My ex did file 3 of these documents, but they're all free filings, so she incurred $0 in costs. Her attorney prepared 3 out of those 4 filings. The real party and interests answer to my petition was a substantial document. That's the first time that my ex's attorney has had to file anything in any of these cases involving my attack on the confidential address program. So it's not like I can say that she is regurgitating arguments because she hasn't had any other opportunity to confront me on this issue. So all of the research that she would have done would have been for the first time, and I imagine it would have taken her a while. She does kind of jump on the government's train partway through, and she joins in all the government's arguments, but she still adds a few. So I'm hesitant to say that it's going to be less than 2 hours. I feel like 4 hours might be too much, given the fact that there could have been more to it. So I'm going to say 3 hours for the answer. The verification, that would have been like no, she would have needed to talk to my ex and have her come in. Probably would have been 25 minutes for the verification. The certificate of service, that's like a 1 or 2 page piece of paper, so probably 5 minutes for that. So we're looking at 30 minutes there, and then we've got the order from the Supreme Court, but that's just to the clerk. That's not even an order to me. That's an order to nobody. It's an internal order. So let's just put that at 0. So we have 30 minutes for those 2 subsequent filings, 3 hours for the main filing, which is going to come to 3.5 hours at the rate of $250 an hour. That's going to be $750 plus $125. So $875 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.